Here we are, back again. Today we're going to finish up Chapter 15 by talking about some of the constitutional protections that you have as it has to do with criminal and civil law. And a lot of these I'm going to go through pretty quick because we've spent a great deal of time talking about the Bill of Rights. But before we get into that, as always, your joke of the day. So, I don't know if you guys heard, but there was a story that popped up on the news last night where this individual was suing an airline because they lost his luggage. But in the end, he lost his case. So there you have it. As always, that was really bad, and I'm sorry, but doing the best that I can. So now we get back to POD. So as far as the judicial branch and interpretation, we've already talked about a lot of these, but just to kind of quickly go through them again, what are the basis for judicial branch interpretation? Now, the first one's going to be written law. So what acts of Congress have taken place that should establish whether or not somebody has certain freedoms, what freedoms you have in school as it refers to speech and things along those lines. But I will say, though, just because it's a written law doesn't guarantee that it is constitutional. And I think we've seen that a lot, and we've talked a lot about that in class, that just because Congress passed it doesn't mean it's constitutional. So that's going to be the first one. The second one is judicial precedent. So what has been done in history when they've dealt with a case along the same line. And sometimes precedents work, but they don't always work, because there have been some really bad precedents. Thinking about the Dred Scott decision where they said African Americans can't sue in court. Talking about Plessy versus Ferguson, where you can have separate but equal. Even on one that I learned of recently called the Lochner decision, where they said that states can't say how many hours people can work, basically making it so if a job wants you to work 16 hours a week, well, you have to work 16 hours a week. So, precedents are used a lot of the time, and when you read an opinion by a Supreme Court justice, they go through precedents, they go through the different examples that were stated and done in years past, but they can't overrule precedent, and boy, is that a good thing that they can do that to make up for a lot of the wrongs that have been done in the court. And then we've talked about this one, but stare decisis, let the decision stand. It was already decided. We don't really have any other implications to change it, so we're going to let the decision stand. But then the next sources of legal rights, they're going to come from the U.S. Constitution, and really there's two major parts. It's going to be Article 1, which deals with the legislative branch, and then there's going to be constitutional amendments. So we'll start to go through those individually. Now, Article 1, what it does for your most basic legal right is it provides for writ of habeas corpus, which means that if you are accused of a crime, you have to be told what you are accused for. Now, this can be taken away. It's pretty controversial. Abraham Lincoln did this during the Civil War, where he suspended writs of habeas corpus, but he did that to try to keep people from the North switching to the South. So, but you have to be told what you're accused for. You have to have that initial trial being told you are being charged with this. Here is what your bail could potentially be. Again, bail is not a guarantee, but you have to be told what you're charged with. So that's something that is good. So you can't just be arrested and sitting in jail for a year and a half and say, all right, we're going to accuse you of littering because we saw you throw that Snickers bar out the window. Which, don't do that. Don't waste a Snickers bar. And also don't throw away your garbage. Or do throw away your garbage. Man, I'm messing up a lot here. Alright, then after that you have forbids, bails, or bills of attainder. A bill of attainder is being thrown in prison without actually having a trial, which used to happen in England, and then ex post facto laws, which you can't be charged with something that you did while it was legal, even though it's illegal today, which does get confusing. Really what it boils down to is we know the speed limit on 49 is 65 miles an hour. If they change that to 45, they can't go and write everybody tickets because we drove faster than 45 miles per hour. So Article 1 is going to be a big part of that. Constitutional amendments, you have the Bill of Rights. We'll go through those specifically. Requirement of equal protection, which is going to be within the 14th Amendment, and that has been one amendment that has really been stretched pretty thin, which what people are going to argue for equal protection. And then also due process of law, which is going to be in the Fifth Amendment, and then also the 14th Amendment. Now, talking specifically about the rights, and I know my image is covering up the top there, but guaranteed rights of those that are going to be accused. So, talking about specific ones quickly, the Fourth Amendment, which the Fourth Amendment, we've talked about it before, but it prevents citizens against unreasonable searches and seizures. So there has to be probable cause. You have a right to be secure in your home. Which I know I went over the example of when somebody said I hit a car and fled the scene, and a cop showed up at my house. That's not necessarily unreasonable search and seizure, but if they do want to come into your home, you have to allow them to, or they have a search warrant. But really what this does is it helps out with making sure that you have certain securities, and police officers don't have unlimited authority. After that, you have the Fifth Amendment, which the Fifth Amendment, there is a lot to it. But there's really three major ones for this purpose that we're going to be talking about with criminal law. Now, the first one is you don't have to be a witness against yourself. So sometimes in court and in TV shows, you're going to see people say, I plead the Fifth. Which that just means that you're not going to compel a witness against yourself. It's going to be up to the other side to prove your guilt. I will say, though, if you plead the Fifth, it doesn't look good. Because if you're unwilling to answer a question, well, why are you unwilling to answer it? You probably did something that you shouldn't have. And this was brought up in the case of Miranda versus Arizona, where an individual admitted to murder, but wasn't given his Miranda rights. So because of that, he was found not guilty and was able to walk free. Protects against double jeopardy. So if you are found innocent, one example I use in class all the time is talking about O.J. Simpson. He was found innocent in criminal court. Now, there was rumors, and I haven't really looked into this too much lately, but he was going to write a book about getting away with murder. Because he was found innocent the first time, he could not be tried a second time. So that's what double jeopardy is going to refer to. And then lastly, it establishes the right to a grand jury for people accused of a serious crime, which a grand jury basically is a group of usually it can range from 9 to 15 people that are going to meet, and they basically just decide whether or not there's enough information for a case to potentially happen. And then after that, it goes to the actual court case. But a grand jury is kind of that step before. After we have the Fifth Amendment, we have the Sixth Amendment, which what that does for your criminal rights is going to be established the right to legal counsel. So, this was established in Gideon versus Wainwright, where Gideon was trying to get the court to help him in a legal battle. They said no because it only had to do with capital cases, and he was accused of stealing money, and I think it was wine from a bar. And then the Supreme Court said nope, everyone has a right to legal counsel. So with that, that's going to be a big part of the Sixth Amendment. You also have a right to a speedy and public trial by an impartial juror, and then gives accused people the right to question witnesses against them. So oftentimes, if a witness doesn't show up, they can issue what they call a subpoena, which basically is a legal document forcing them to show up. Now, a lot of times when people ask me is, do you have to have a jury trial? And there's kind of two ways around it. The first one is you can request a bench trial, which if it's a bench trial, it's a ruling from the bench, meaning that the judge is going to be the one to determine whether or not you're innocent or guilty. And then the next one is going to be a plea bargain. Now, oftentimes plea bargains, they're done for a variety of reasons, but the big one for plea bargain is if you admit to something, or if you say, yes, this happened, but there's a bigger issue going on, and you give information that can get somebody else in trouble, they give you a lesser sentence. Or just sometimes if you just say, all right, look, if I admit I'm guilty, can I get 3 years in prison instead of 6 years? And a lot of times they do that to speed up the whole process instead of having it drag on and on and on. But plea bargaining is going to be a way to avert that. And then you also have the Eighth Amendment, which outlaws cruel and unusual punishment. We've talked about how that has been controversial in the past with the death penalty, and then it prohibits excessive bail. So, if you are on trial for, a bad example, but I'm just thinking off the top of my head, littering a Snickers wrapper, and you're arrested, you can't be put in jail and say, all right, your bail is $10 million. The punishment has to fit the crime. But they don't have to give you bail. If you're a flight risk, if they think that you're going to potentially leave the country, or they think that what you did was so bad, something like murder, that they're not going to allow you to leave, and you have to stay in jail until your trial is going to conclude. So there you have it. Those are your constitutional rights as they pertain to criminal law.